So, good evening, all of you. Today is our sixth day of 1 week capacity building program of emerging trend in human rights. So, today we have our esteemed guest, Mr. Karman Singh Johal. So, he'll be talking about judicial approach to enforceability of human rights in India. So, let me introduce Mr. Karman Singh Johal. So, Mr. Karman Singh Johal is a practicing lawyer and represents his legal firm Johal Associate in the High Court of Jammu, Kashmir, and Ladakh, with an experience of more than 10 years at the bar. Carrying forward the lineage of father, who is the senior advocate at High Court of Jammu and Kashmir and Ladakh. Advocate completed his master in law international legal governance from prestigious institution of University of Durham at United Kingdom. He has an experience on the original side of the law, apart from being adept in dealing with various matter in the trial courts, high courts, and other tribunals in Jammu, Kashmir, and Ladakh. He has diverse practice in arbitration, judicial, and quasi-judicial forum. So, with this brief introduction, on behalf of organizing committee, we welcome you, sir, to proceed with the session, and over to you. Thank you very much.
Alpesh, I'm grateful for these kind words that you have extended towards me. I don't know if I'm worthy of it or not, but I appreciate that. And besides that, first and foremost, I would want to thank you for having this occasion and the initiative of imparting and sharing legal education, particularly the principle of human rights. I think which goes down to the core of the human basis, the rule of law, and our existence as human beings. It is very, this initiative is appreciated, and more so because it is pro bono. So you are doing great service to humanity. And in fact, me as a lawyer, I feel that my apart from my professional obligation, it also is my moral obligation to educate people on, first of all, law, my clients on law, people I deal with, I make it a point that they are educated and made aware of their rights, because you'll have diverse, type of clients, people who are not much aware of their rights and people who, are extensively highly aware. But then as lawyers, we, try to bridge in the gap between the judiciary and the normal public. My role is to act as a bridge between the judges to convey the point of view of my client to the judges and portray their cases on the basis of legal principles and codified laws in order to get them justice. Apart from this, I would also like to thank you guys for accommodating me for today. Instead, I was scheduled to speak on Wednesday. I could not be there because of my some personal difficulty and professional difficulty that I had. I'm grateful to Dr. Priya that she took up the occasion, and instead I'm made to speak today instead of Saturday. So we've all gathered here for a discussion on the judicial approach and the approach of the courts to deal with the principles and to promote the principles of human rights as they exist. Now, before we go any further, I would we all know that human rights, by means of their existence and by means of a layman understanding, are in fact the rights which are vested upon all humans only by virtue of them being humans. Me and you enjoy those rights only because we are humans, so we have certain rights. For example, the right to live with dignity, the right to drink clean water, the right to breathe clean air, the right to be respected, the right to be from everything that you can imagine, and everything that coexists with your existence is given to us by rights, which are vested with us, in terms of the constitution, the codified laws, sometimes practice, sometimes culture, sometimes the customs which have been a part of our system from the time immemorial. Now, for today's lecture, I would be basically, we would first visit and go about the origin of these rights, that where did this concept originate in first place, and how this evolved as a law, or how did this concept evolve as codified. And because originally these laws were supposed to be soft laws which lacked enforcement in the prehistoric ages, These laws were supposed to be, soft laws which lacked enforcement. It was very difficult to enforce these laws. So from the origin, we come to the Indian legal system, that how our country and our constitution has evolved these rights, has incorporated these rights to become a codified law and to be recognized as principles which govern us as of date. Then primarily my focus would be on the Constitution of India, which has recognized these rights, and how our courts from the inception of the Constitution in the year 1950 have protected and safeguarded these rights and given us the beautiful Constitution that we have today. Now we'll go further with the, I would also in between, I'll also, share my experiences of the limitations and challenges that I feel are existing in our legal system as well as they exist in any other legal system. So this would be a blueprint of what I'm going to speak of today. To start with, I say that we go upon the concept of human rights as it's originated. We would all know that, the world was governed by the principles of expansion. From the times of Alexander the Great, from the times that, the land masses in this world came to be discovered, the need of the hour perhaps then was expansion. Expansionism was the need of the hour. Christopher Columbus and all. Now in expansion and in taking over territories, one thing always came analogous with these expansion is that the people you conquer or the emperors taking over more land become your slaves. More than becoming your slaves, they become your, if not slaves, then they become your pupils. You want to govern those people and you want to rule over them. Now, for the purpose of ruling over them, there are some issues which would need appreciation, and which would also need appreciation to the extent that which would mean that how these people eventually came to be governed and what vested these rights upon these people, in the sense that we go back to the 1539 BC, when the concept of human rights in its essence originated in 1539 BC, when a Persian emperor by the name of Cyrus the Great conquered and won battle over the territories of Babylon. Now, in that conquest, what was fantastic was that the first time ever, since we were governed by the principles that you take over land, you take over these people, you either kill the prisoners of war or you subjugate them to whatever your wishes are. But for the first time in 1539 BC, as back as in 1539 BC, imagine that. As back as in 1539 BC, the Cyrus the Great, the Persian ruler, which I just referred to, in fact, after his conquer over Babylon, granted people freedom. Granted people freedom in the sense that my people, the people who I have, the citizens of then Babylon, would in fact be within their rights to practice, number one, their own political beliefs, their own religious beliefs, and their own practices in terms of customs that they have been doing since the times. So this, in fact, was the first time something unusual happened, that generally the people who were subjugated or who were conquered, instead of now being prisoners of wars, were given rights to live as free citizens and were liberated in the sense that I conquer upon you, but I still give you the liberty to, practice your own rights, practice your own beliefs in under my conquest. So this is how the system and idea of human rights emerged in first place. And now we are referring to 1539 BC. Of course, the conquerors and the history has it that the ideas developed. These things were only a matter of principles and were only a matter of wisdom of that one ruler who believed that this is the right way to go about it, but it was nothing codified. It was on whims and fancies of the rulers. The sovereign were the rulers. Their wishes and their wishes were commands for the public. So for the first time, and apart before going to the codification of these laws, any chapter or any debate or any lecture, if I may call so, on human rights would be incomplete without the cover note on the principles of Magna Carta, without the cover note of the rule of law as it was established for the first time and codified in the year 1215. An English concept, the British concept of Magna Carta were in fact general principles of rule of law. That, sir, these principles are the principles that should govern every governance, that should be followed by every governance. And the principles instead included that for the purpose of ruling, what is important is that you respect your citizens. The hallmark for good governance would be that the citizens are respected and citizens are given some rights and some liberties to which, by which they might, they could have a political affiliation, they could have a religious affiliation, they could have the rights to think, eat, wear what they want. So for the first time, the good governance principles came to be codified, and in a written form, the rule of law to prevent people from arbitrary prosecutions and incarcerations evolved during the reign of King John of England in 1215. The first codification recognition in these laws came to be by means of the English Bill of Rights, which was signed, which was again an English law doctrine, which was an English law codification, which was signed by William III in 1689. Now, at the end of the day, the principles which were of the 539 BC of one of the rulers, traveling from 539 to the 16th century and 15th and the 16th century, saw that these bills, saw that these rights and these problems have to be codified. There is a necessity to have a codified language. There's a necessity to have a codified idea of these things so that these are not merely soft laws, these can be enforced. So therefore, the English Bill of Rights, the English law document, which was signed for the first time in 1689 by William III, recognized the rule of law as a principle of governance. Another essential component of the English Bill of Rights was that in England, maybe not significant for us, but in England, the English Bill of Rights also was, in fact, the document which permitted the monarchy and the parliament to coexist. The English adopted and gave themselves their legal system in a sense that monarchy, sir, we will be subjugated, we will be under the monarchy, but we'll have a parliamentary system of government that the people would be elected by the people. That the parliament would be elected by the people. This was basically the English Bill of Rights of 1689 was basically the genesis of the constitutional monarchy in England. Now, inspired by this English Bill of Rights, the US Bill of Rights, as we all know it, was in fact, because this thing wanted diversification, these principles wanted recognition throughout the world. England had its Bill of Rights, which talked about rule of law, which incorporated the principles of good governance through the Magna Carta in 1689. Then the US Constitution was, then the United States was inspired by this idea and incorporated the US Bill of Rights and incorporated the similar principles of the Magna Carta and rule of law and good governance in the year 1791. Now, after the incorporation of these principles in 1791 in the US Bill of Rights, the need for them, of course, further widened. And then we had the Declaration of Right of Man and Citizen in France. This declaration of the 1789, in fact, was the declaration which motivated the French Revolution. The French Revolution, as we all know it, is the revolution of the biggest kind, which continued for approximately a decade so that the rights of people could be recognized. Now, here in France, with the evolution of time, these things were more intricate. These battles, these struggles of humankind were more intricate, and people started talking about the concepts of, it was new. It was new in the sense that, like that is why I started with 539 BC, that the conqueror conquers a territory, people are mine, land is mine, whatever is under this territory is mine, and they are to, if I wish, they have to live as my slaves, if I wish, they have to live as independent people. So the need was, in the French Revolution, for the first time, people started talking about the concepts like all men are born equal. This was new to that age. Today we'll casually take it, but all men are born equal. This was in fact something startling for those times. That how could men be equal? How can a king be equal to a slave? How can, this is not the concept that our prehistoric world has given us. So all men are equal. There is a right to remain free. There are equal rights for all. That liberty is something. Liberty in the sense that I am free to do what I want. Right to hold and retain property, one of the very essentials of existence. These things, in fact, and then more so, direct or indirect participation of people in parliamentary affairs, direct or indirect participation of people in governance, direct or indirect participation of people in the rule, that who is to rule us. It is no more the time that the conqueror will come and rule us. It in fact is a time where people need participation in parliament, where people need direct or indirect, policy. People have to do with the policy decision, because at the end of the day, these are the policy decisions which are made for me, as a citizen, and these decisions are to govern me. So these concepts, since originated in France in 1789 and gave birth to the French Revolution, which continued for over a decade. And that is why the countries, the first world countries have these things, because they started early. Because in the 7th, we are talking about the 16th century, 17th century. The first world countries are first world countries today because they liberated early, because they liberated since 300, 400 years from now. So the concept, basically the idea is to say that the concept evolved. Now, evolution of concept remained centric for a very long time to countries. England has it, France has it, United States has it. What about the world? What about the world order? As a consequence of conflicting world orders, as a consequence of conflicting, uh, opinions on how the world is to be governed, and on how things are to be, who wants to, who, the might is right was the concept, that who will rule whom. We had the First World War. Now, First World War was, in fact, as we all know, a global genocide, loss of life, and everything related to it. The earth turned upside down. It had devastating effects. Any war would have devastating effects. We had the First World War. We had to learn our lessons from it. As a consequence of which, the first time a realization come that independent Bill of Rights, like the US Bill of Rights, the English Bill of Rights, the Declaration of Right of Man and Citizen in France, could be your own things, but we need an association. We need an organization which can come together and which can, take this world forward from here. Thus, we had the League of Nations for the first time. The League of Nations, the war cry of the League of Nations was all the countries in minority in the First World War, and the countries, who suffered in the First World War. These countries wanted that, sir, we can't be oppressed for immemorial times. We can't be oppressed. We can't be subjugated or subjected to arbitrary arrests. We can't be subjugated to arbitrary conquests and everything. So, as a consequence of which, the League of Nations evolved, and League of Nations, the effort was to, keep the world together, and the effort was that everybody comes together to evolve a system which we have it, that these rights, the human ethos, the human respect, the human dignity is respected and honored. Now, we had the Second World War then. The Second World War, in fact, is a proof that the League of Nations did not do what it was supposed to do, could not justify its job. It did not do what it was supposed to do, as a consequence of which, after the Second World War, the German Holocaust 6 million Jews were killed, as we all know. 6 million Jews. This is a Holocaust to a different level. Homosexual discriminations, persons with disabilities. There were so many challenges. Expansion was the problem. So, crime against humanity was the thing that everybody wanted prevention against. So, as a consequence of which, the failure of League of Nations, the Second World War, brought us to the United Nations. All the countries in the world got together that no, sir, we can't afford a third world war. We can't afford something that is that holistic or that devastating that could cause a war again, because we can't afford that. So, as a consequence, the United Nations was established in the year 1945. The UN Charter, which came to be signed by 50 countries of 50 world countries, came together with a unanimous decision that world peace is the need of the hour, human dignity is the need of the hour, international cooperation and coming together is the need of the hour. As a consequence of which, soon after the UN Charter, soon after the establishment of the United Nations, the Commission of Human Rights was established under the UN Charter, Article 30 of the UN Charter, which gave us the Universal Declaration of Human Rights. Now, this Universal Declaration of Human Rights was, in fact, a first global document in the sense that recognized and categorized certain rights as they were and codified these rights in a way that at least these rights are written somewhere, that to live with dignity is something that is written and codified in the sense that everybody has agreed to it. Okay, in the UNDH, in the Universal Declaration on Human Rights, we agreed you can't be an oppressor to me. Look, Mr. America, look, Mr. Canada, you can't oppress me for the reason that we have agreed on these principles that you will not be an oppressor. I have a right to life, I have a liberty. So these rights for the first time were then codified in UNDHR, United Nations Declaration of Human Rights. Now, after the development of this, the concept further evolved. The life liberty concept, the right to equality, protection from discrimination, these were the first league of rights. These were the first group of rights. These were the primary rights. Now, evolution happened to include civil political rights, social economic rights, social economic justice chahiye, civil political justice chahiye. We need participation in the politics. So there were three more after the Universal Declaration of Human Rights. There came the International Covenant of Civil Political Rights. Then came the International Covenant on economic, social, and cultural rights, which again elaborated the principles of, at the end of the day, human dignity and better existence. Now, what have these treaties, out of these covenants, what have we as a world achieved? Now, these treaties have resulted into signing of more than 20 25 world treaties, 20 to 25 world treaties, including the right of children, including the protection for refugees, including the discrimination against women, and so on and so forth. So these principles basically were the principles which, that is how our world grew, and that is how the concept of human rights evolved. And we came back to we came back to 1945. That is how from 539, from the Magna Carta, these principles eventually evolved, and we were where we were in 1945. Now the question would be that how these principles could be borrowed, and how these principles could be applicable in our legal system. Look here, that we have these principles which are, again, so once you say that they are soft laws, there's no enforceability, there was the need to make them enforceable. So with the development and advancement of the world together and independently, with countries advancing at their own paces, all legal systems evolved. All countries had their own legal system. Now, since we all know India was a British colony for the longest time, we were governed, we were ruled by the British. And till the evolution of these covenants, the international soft laws, we were governed by what was called the Government of India Act of 1935. Now, the Government of India Act of 1935 was in fact a British Act of Parliament, which governed us from the British era till our independence in 47. Now, these acts, this Act of Parliament, in fact, was again something that decided that India has to gain independence in 1947. We, the Britishers, do not want to retain India as a colony. So, therefore, independence has to be given to India. As a consequence of which, the act was overridden by the Constitution of India as was made by our founding fathers in 1950. Now, the difference between the very important difference between the British Act, the Government of India Act of 1935 and the Constitution of India was essentially the part 3, which is contained in the Constitution, which is the chapter on fundamental rights. Now, what were these fundamentals? To look at the Constitution of India, just to give an overlook, the Constitution of India, in fact, is a document with one of the longest written constitution, has more than 394 articles. The Constitution of India was designed to have part 3 in the Constitution, which were the rights which were so fundamental, which again borrowed the ideas from all different constitutions of the world. We borrowed it from the US Constitution. We borrowed it from the Swiss Constitution. We borrowed it from the Japanese Constitution. So the Constitution was made in parts, wherein the part 3 of the Constitution was supposed to be the chapter on fundamental rights, which contained all these rights, which were the parts of the rights which we started with: the right to life and liberty, equality, freedom, the 7 freedoms that we have. All these rights were contained in part 3 of the Constitution, and the only difference between the Government of India Act of 1935 and the Constitution of India was the part 3. The part 3, in fact, and this in fact was the difference, that what we were governed by and what was to govern us. We were to be now governed by the Constitution, which had the part 3, which recognized all these rights which were there. Now, apart from the fundamental rights chapter, which contained the primary and the essential rights, we also had a part on the directive principles of the state policy, which in fact meant that these principles were directive to the state for the purpose of making welfare legislations, for the purpose of achieving social economic justice, for the purpose of achieving, equality, for socialism. These principles were promoted through the directive principles of the state policy. The rights which were recognized in the directive principles, in a sense, or primarily were the rights which were codified in the International Covenant of Civil and Political Rights and the Cultural, Economic, and Social Rights. Whereas the Fundamental Rights chapter took the rights from the Universal Declaration of Human Rights. Now, the difference again between part 3 and part 4 in the legal practice would mean that part 3 rights, the fundamental rights, are the rights which are to be enforced through the court of laws, through prerogative writs. The violation of these rights is impermissible in law. Whereas the fundamental rights are not to be so enforced, which was the principle, which was the idea by which these rights, the framers of our constitution, incorporated these rights. Now, after the constitution was evolved, we had challenges to the constitution itself. The idea that I want to go forward with is that we need to have a basic understanding that, sir, part 3 of the constitution can't be enforced this is the only part of the constitution which can be enforced straight away by means of writ petitions before the High Court under Article 226 of the Constitution, or by means of writ petition straight away to the Supreme Court under Article 32 of the Constitution. But the directive principles, any act of the parliament, any legislation, any executive order passed infringing my fundamental rights will have to, in fact, be challenged by means of a writ petition, which is violative of article, which is violative of challenged by means of a writ petition, which could lie straight away to the High Court or the Supreme Court. Whereas the directive principles are not to be so enforced. However, the position of law changed with the evolution of law and by law of precedent in SP Sampath Kumar versus Union of India, when the court said that the Supreme Court of India said that the directive principles can also be enforced as fundamental rights. It can also be enforced in the writ petitions. Now we have the constitution, we have the part 3, now we have the directive principles. How do we go forward from here? The question of going forward, in fact, would not be complete without the basic challenge to the constitutional ethos. Now, what was the need of the hour was that since after we gained independence in 47, the Constituent Assembly, which drafted the Constitution, in fact, was given the challenge of bringing the First Amendment, because the election, after the first election where Pandit Jawaharlal Nehru was elected as the President of India, as the Prime Minister, I'm sorry, the Prime Minister of India, the first election had it that the war cry of Jawaharlal Nehru was that we want agrarian reforms, and to a massive scale. Because of these agrarian reforms having at a this political idea that we want agrarian reforms at a massive scale, the constitution was amended for the first time in 1951 by the First Amendment Act of 1951. Now, what this First Amendment purported to bring a change in the constitution was that the fundamental rights which are guaranteed under part 3 of the constitution would be violated by the governments if the action of violation was related to taking over of a property, acquisition of a movable property, of an immovable property, and for the purpose of taking over of the immovable property of a citizen, the principles of fundamental rights could be abridged, could be thrown to winds. This in a sense was the purpose, and in a sense was the outlook by which the Constitution's First Amendment came to be. Now, the First Amendment introduced Article 31A and 31B in the Constitution. Now, what we have is the amendment which says that, sir, you have given me fundamental rights, out of which the right to life and liberty is a fundamental right. The right to equality is a fundamental right. The right to preach, practice, propagate my own religion is a fundamental right. The right to enforce these fundamental rights directly through the writ courts is a fundamental right in itself under Article 30. All these rights you have given me, that is okay. But you have taken away these rights by means of this amendment, which says that once the matter is about acquisition of property, then the decision taken by the government would be taken notwithstanding anything which is contained in the fundamental right. So, meaning thereby, for the purpose of taking over properties, the government of the day need not take care of my right to equality. The government of the day need not take care of what was the consequence. I'll try to, fit it in an example. The consequence was that my house has to be taken, has to be acquired for a public purpose by the government. Let's say the public purpose is widening of a road. Now, in that road widening, my house is taken, but my next door neighbor, the government excuses him for the reason that Mr. Johal's lawn is good enough, and has good flowers, we'll take that house, but not the next door neighbor because we don't like it. What was wrong in that? That could have been easily done, because 31B said for the purpose of acquisition, fundamental rights of Mr. Johal do not matter. That was the amendment. That was the purport of the amendment. And it was not to be affected by the principles of equality. I say I have to be, me as a citizen would be pitched against a neighbor if you have to take away my property for a public purpose. Me and my citizen have to be equated on an equal pedestal. There is a right to equality. There is a right against arbitrariness. There is a right for the government actions to be reasonable. So this government action of taking my land and excusing him, in fact, is arbitrary. It is not in consonance with the principles of Article 14 of the Constitution. But I could not have said that back in 1951 because of the First Amendment. Because the Constitution was, the amendment was aimed for taking away property, notwithstanding that it affects the fundamental rights of some. As a consequence of this, the amendment came to be challenged before the Honorable Supreme Court in 1951 in Sajjan Singh versus Union of India. Now, the Supreme Court in Sajjan Singh and Union of India versus Union of India did not disturb the First Amendment, did not disturb the Second Amendment, did not disturb Article 31A and 31B of the Constitution. In fact, upheld them. So the position in 51, even after we were given the Constitution, was that you might have these rights, but there is no enforceability to these rights to the extent of taking over of the property. Now, before proceeding, it is also very important to know that Part 3 starts with Article 12 and then goes down to 13. Article 13 has it that any law which is made and is inconsistent with the fundamental rights of a human, of a citizen, shall be void to the extent of that inconsistency. So no law would be made by the legislature which could violate my fundamental rights. And had that law been made, or had that enactment been enacted, or had that order been given effect to, that would be void to the extent that it is inconsistent to matter. So the prohibition contained on the parliament, on the legislature, to enact a law violating my fundamental right was contained in Article 13. Now, since in Shankari Prasad versus Union of India, the Supreme Court did not disturb this position, and the government of the day got more powerful, that okay, we were first talking about laws relating only to, laws made in the First Amendment relating only to taking over of the property. Maybe let us try to widen our wings more. Now, instead, another constitutional amendment came to be made and given effect is the 17th Amendment of the Constitution, by which 31B 31B talked about the ninth schedule of the Constitution, that every law or every local law which is introduced in the ninth schedule of the Constitution would be immune from judicial review. The powers of judicial review are taken, in the sense that the parliament enacts a law, all that the parliament, because the government became stronger after Sajjan Singh's verdict. All that the government needs to do is that you enact a law and put that law in the ninth schedule. Only by means of putting that law in the ninth schedule, your power, the right of the citizen to call in question that law goes, because that law is in the ninth schedule. So, as a consequence of this draconian amendment, the challenge was laid to this before the Supreme Court under Article 32 of the Constitution, that sir, this approach, this amendment again hits the fundamental rights. You can't do this. In Sajjan Singh versus State of Rajasthan. Now, the Supreme Court for the second time did not agree with this contention. The question before the Supreme Court was, and the debates, arguments in the Supreme Court happened to the extent that what is the meaning of law? Would law, as used in, we refer to Article 13 of the Constitution, that no law, the state can't make any law which abridges or violates fundamental rights. The debates which happened in Sajjan Singh were in fact that what do you mean by law? Would law include constituent law? Would law include the law made by parliament? Would law include the powers of the parliament exercising under Article 330, 368, that the powers were there to amend the constitution? Would law include the powers of the constitutional amendments, or it has to include only the legislative amendments? The Supreme Court answered this question in negative, and it said in Sajjan Singh again in 1965 that the amending powers of the parliament would not include, as contained in Article 13, would not include the powers, the amending powers of the parliament as contained in Article 13 would not include the constitutional amendments, the amendments made to the constitution. So, meaning thereby, you make a constitutional amendment, that constitutional amendment will survive on the touchstone that, sir, this constitutional amendment can be made, and this constitutional amendment is not a law in terms of Article 13. So, therefore, a law can be made that violates fundamental rights. Now, this being the position, the problem was that we were governed by, the governments kept on coming and going. The problem was that we were governed by a principle till 65 because the powers given to the parliament were so unfettered that the fundamental rights became as good as soft laws which were earlier in the 59s. It was about the popular government that they want to take away your rights. Nothing stops them. Nothing stops them. Or going by that, the parliament was well within its power to say, let's say, for example, that, the right to life and liberty is taken away. No citizen should be given life and liberty. He can arbitrary arrests could have, because the parliament could have done so. Or maybe the parliament passes a law, says that we are going to give our country back to the British. Nothing stopped the parliament. Nothing stopped the parliament because, as in this Shankari Prasad and Sajjan Singh, the Supreme Court, the Constitution Bench of the Supreme Court said that the power to amend the Constitution has no restrictions whatsoever. The powers vested with the legislature to bring the Constitution on its head has no restrictions. No fundamental rights have to be taken care of. Nothing has to be taken care of. So the parliament was well within its powers to give India back to the British. Nothing stopped them. Or the parliament could have passed legislation that, okay, from today onwards, that, the popular government after 5 years of election would say that, no, we'll run for the term of Lok Sabha is increased for another 5 years. We'll call elections after 10 years. This was arbitrary. But nothing stopped the parliament to do so because of Sajjan Singh and Shankari Prasad, because the Supreme Court did not agree that the amending powers of the parliament could not abridge fundamental rights. This was the principle that was tried to be, that later came to become the basic structure of the Constitution. Now, what happened? This position remained so from 1951 till from the inception of our Constitution till 1961 in Golaknath versus State of Punjab. Now, Golaknath was in fact, back then, the 11 judges bench of the Supreme Court decided and adjudicated. So what was Golaknath? Golaknath, in fact, was two brothers in the state of Punjab. They owned 500 acres of land. This in fact, were the facts of Golaknath. Two brothers in the state of Punjab owned 500 acres of land. The state of Punjab came up with the legislation in the name of Punjab Security and Land Tenures Act. Now, what the act intended to do was put a ceiling limit on the amount of land a person or an individual could hold. As a consequence of which, these brothers, the ceiling limit was put that each family could not hold more than, let's say, 30 acres of land. So the brothers jointly, their right over 500 canals of land, 500 acres of land was taken away by this act of the Punjab government, and the ceiling limit being put to 30. So from 500 acres, they were shrink to 60 acres, and rest of the land went to the state, ceded to the state. Now, being aggrieved of this provision of law and this act in particular, the challenge came before the Supreme Court now in a different set of facts. To the 17th Amendment, which was upheld by the Supreme Court in Sajjan Singh, the challenge came again to the same amendment. That, sir, you can't do it. You have made an act which has taken away my fundamental right to property as it was then under Article 31. You have taken away my property without an explanation. This is abridging my fundamental right. You can't do it. No act or legislation can, intervene into this and take away my right. Now the Supreme Court, for the first time, came here and intervened and said, and the examples that I'm quoting now, that nothing stopped the Indian Parliament to say, pass an order that acquisition would be done by, or maybe the bills. We don't need bills in the Parliament. We don't have to table a bill in the Parliament to make it a law. All that we need is a governor of a state, or let's say the SSP of a state, or a deputy commissioner of a state is vested with the powers to pass any law. No debate. The ethos, the foundation on which our constitutional is established would go to winds if that was permitted. Realizing that and going from there, the Supreme Court said no. 11 judges bench of the Supreme Court in Golaknath versus State of Punjab said no, you can't do this. The Parliament's power and the power to amend the Constitution has its implied limitations. Now, what were these limitations? The powers vested with the Parliament were so much so that they could implied limitation to the extent that they can't take away the fundamental rights of a citizen. They can't disturb a fundamental right of a citizen. Now, the government was on a back foot. The government was on a back foot for the reason that the fundamental rights of a citizen, we can't take it away. And as a consequence of which, the victory was to the rule of law in Golaknath versus State of Punjab. Now, Golaknath victory, in fact, was to adjudicate that fundamental rights can't be disturbed by the Act of Parliament. This position was again sought to be changed by the government. To neutralize the effect of the Golaknath judgment, the government came up with the 24th, 25th, and the 29th Amendment to the Constitution. Now, what was being sought by these amendments? The 24th Amendment and the 25th Amendment, in fact, wanted that for the purpose of giving effect to a particular directive principle as contained in Article 39 B and C of the Constitution, to give effect to that directive principle or to make law in furtherance to that particular directive principle, the basic structure, doctrine, or Section 30 or Article 13 of the Constitution shall not come in the way. Meaning thereby, any law could be passed in furtherance of the directive principle contained in Article 39 B and C, which took away the fundamental rights of the citizens. Now, this again came to be challenged before the Supreme Court, the 24th, 25th, and 29th Amendment in the famous Keshavananda Bharati versus Union of India. The 13 judges bench of the Supreme Court said that no, you can't do this. You can't, again reiterated Golaknath, upheld Golaknath, and said that the basic structure of the Constitution of India can't be amended and is beyond the pale of amending powers of the Parliament. The Parliament can't amend the basic structure of the Constitution. The Parliament can't take away the fundamental rights of the citizens. The Parliament can't make any legislation which amounts to abridging these fundamental rights. Now, with this ratio in Keshavananda Bharati versus Union of India, we were given the basic structure doctrine and our fundamental rights came to be protected. Now, what happened later was again, you see, the emergency was imposed, national emergency imposed. Madam Indira Gandhi lost elections. Her elections were challenged. 42nd Amendment made to the Constitution. Now, on the test stone of basic structure, what Indira Gandhi wanted to do was, in fact, by the 42nd Amendment, was that she said, after the Allahabad High Court upheld the petition filed by Raj Narayan saying that there was malpractice in election, therefore her election as Prime Minister is set aside. Her election by which she's become the Prime Minister is set aside, after which she imposed emergency. What was sought to be done by the amendment was, in fact, that for the purpose of adjudicating an election petition of the Prime Minister, the powers of the Supreme Court were taken away. The Supreme Court's power to adjudicate an election petition are no more there. In fact, once it comes to the election of the Prime Minister, the rules are to be governed by an act which is to be yet to be made by the Parliament. The rules which will apply to that election petition would be by an act which is yet to be made by the Parliament, and the Supreme Court will not have any powers. Now, using the basic structure doctrine in Keshavananda, incepted in Keshavananda Bharati, the Supreme Court immediately struck down that amendment. No, you can't do this. This would amount to changing the basic structure of the Constitution. This would amount from changing India into from a democratic to an absolute anarchy. It will result in anarchy. Now, this is how the law of President and the Supreme Court and the courts in India have actively safeguarded the rights of people. So to say, day in, day out, that the rights that we so casually take today, me and you as citizens, which are fundamental in nature, the battles to make those rights fundamental were strong, were long, and brings us here where we are today, that no rights are beyond no powers of the Parliament or no government can take away these rights. No, I think I can go on and on, but we are constrained by time. So I would then, the concept of basic rights are there, but for the purpose of enforceability of these rights and for the purpose of the courts to do their jobs, I personally as a lawyer feel that there are a lot of challenges. Now those challenges are in fact the challenges that the citizens face. And I mean, I was referring to a report. In my experience, the biggest challenge is the pendency of cases. The biggest challenge is the pendency of cases. I was referring to a report in 2023 that a total of 60,78,594 cases are pending in the high courts. Imagine that number, 60,778,594 cases pending in the high courts and 4.5 crore cases pending in the trial court in the year 2023. Now, for the trial courts throughout the country to deal with 4.3 crore cases, it is, with the country as vast as I accept, though I accept the fact that the country is vast and things like that, but we need to have a solution to these problems. We need to have a solution to these problems, that because the pendency in the High Court with regard to writ petitions is in fact every writ petition where a fundamental right is infringed, where a challenge is made to a policy of the government, the order of the government, the executive order, where a fundamental right is infringed. So the pendency, even a delay of 1 day in safeguarding the right of a citizen is in fact, you see, a very big challenge that our country is facing. So with that, I think we will summarize this up in the sense that now again these examples will keep on popping in my mind if we continue. We have seen the case, how actively our Supreme Court has been dealing with issues. Like you have seen the suo motu cognizance taken by the Supreme Court in West Bengal. You have seen the role of the Supreme Court during the COVID crisis when the world was under a lockdown. How the governments of the day were made to channelize their health infrastructure, and how the resources were to be divided, how rationing of oxygen cylinders were done. All these things were monitored by the Supreme Court. All these things were for the betterment of the rights of the citizens. All these things were for so that the citizens could be, uh, a citizen's right. The whole system was uh, I have this anecdote from my own experience. I remember during the COVID lockdown, my cousin, in fact, was studying in New York. He, in fact, with New York being a hotspot for COVID, in fact, was stuck in COVID, and because of the lockdowns, he was running short of rations and everything, and food was a problem, and everything else was a problem. It is that time when our high courts started functioning virtually in a hybrid mode. And I personally wrote a petition in form of an email to Honorable the then Chief Justice. She took cognizance of the fact, portraying the problems faced by an Indian citizen sitting in New York. She took cognizance of the fact, and on the asking of one citizen, the ambassador, the Indian ambassador to the US, and the whole system was put on a thread that the ambassador personally started, seeing into it that the citizens are taken care of, and everything which is convenient for the citizens and make their lives easy during COVID is done. So the courts have time and again come in aid of the people, come in aid of the citizens who have knocked their doors. So with this, I think I would conclude that the biggest challenge in my personal opinion is in fact the challenge of pendency. Is in fact for the enforcement of human rights and for the enforcement of any other principle in law, which a right which is given to me by any other legislation is in fact dependency, is in fact the delay in dispensation of justice because of that dependency. With this, I would welcome any questions or any suggestions or we'll open this conversation where all of you can, put in your queries or if you have any, and I should be in a position to answer them.
Thank you, sir. We'll be waiting for the questions in the chat box. As of now, we have received some questions in the WhatsApp. So, can I read it for you?
Mhm.
Sir,
Please
what
go on.
is your opinion about separate courts for human right violation?
Separate what? Sorry.
Sir, just like we have courts for labor tribunal, etc., they were asking what is your opinion about separate court for human rights violation?
No, there are in fact the Human Rights Protection Act of 1993. In fact, is a legislation by which the human rights commissions are in place. Those human rights commissions are the authorities which are enacted by the parliament to check these violations. So all that you have to do is the commission is established. You go forward and you file a petition before that commission. The commission is bound to redress that petition in a time bound to ensure the framework is such that a legislation is put to that effect.
Okay, sir. So the other question is, so you have mentioned that achieving equality for men was significant challenge in the past. I believe the question of when Queen and we compared that is the question related to. So with respect to the current challenges faced by the transgender community, do you believe that we are encountering a similar level of difficulty in achieving equality in that level also?
You see, the Supreme Court has the the beauty of our constitution and our legal system is that we are governed by law of precedent, and the constitution is a document which is still open. The constitution, the powers of the parliament, that is why I was referring to the basic structure, to include, you don't know that the government of the day comes and includes such a legislation which would give equality and give special rights to the transgenders and the other marginalized sections of the society, as you mentioned. So therefore, this and the Supreme Court has done that in the recent times. The transgenders and the you know the these bisexuals, they have been recognized by the Supreme Court. So it is only a matter of time that these things have to evolve, and let us hope that we our system fits in everybody and every person of every speciality.
Okay, sir. One more question that is addressed as latest cases on human rights in the last one decade, which are very important.
I'm sorry, come again. The
Uh,
major
so the
challenge.
so the major cases on human rights in the last one decade. Could you please explain it? Was the question?
I would go by my own personal experience that from day in day out we file habeas corpus petitions before the high courts. Now the principles on habeas corpus petitions is that the government has enacted, particularly in J&K. The trend is more because of it being a disturbed area, particularly in Kashmir. I had the data that in 2021, 861 habeas corpus petitions were filed before the Srinagar Review, meaning thereby 861 people were detained by imposing a law which did not even give them a chance to trial. So we challenge these cases, we challenge these detention orders passed under the Public Safety Act, sometimes under the PIT NDPS Act, Prevention of Illicit Trafficking of Narcotic Drugs. So the government has made those enactments, but the Supreme Court time and again, like recently, I was citing a judgment in one of these arguments for the Sushant Kumar Banik. The Supreme Court says that the detention orders can't be passed as whims and fancies. We have ordinary law in place. We have the Indian Penal Code in place. We have the Criminal Procedure Code in place, which needs to deal with the problems which needs to deal with the crimes. Any citizen is what is the trend? Trend is that okay, a citizen is a history cheater. He has 4 or 5 FIRs against him. You impose a PSA upon him and detain him for 1 year, let alone the trial, let alone everything else. So the ratio precedent in Sushant Kumar Banik laid down by the Supreme Court, in fact, was that the ordinary law once is dealing with this problem, that you have the in ordinary law. By that I mean that you have the provisions to oppose bail applications, seek cancellation of bail applications. These are ordinary provisions of law. Once those remedies were available to you under the ordinary law, the superimposition of of a detention order under a special statute is not called for. So this is one such example that you were talking about.
Okay, in the chat box, we have received one more question, sir. Uh, Person violating human rights, can he or she claim defense under human rights? This is the question, sir.
Can he or she claim defense?
Yes, sir, that is the question.
The defense in fact is that the defense in fact is part 3 of the Constitution. The defense in fact is the enforcement of fundamental rights. The defense in fact is that no act or no violation is permissible under law. I don't get the context of the question, that what exactly does it mean by defense under human rights. So, but in my understanding, what it means is that the defense, in fact, is the constitutional principles which are given to us.
Okay, sir. Thank you for your excellent answers. Now, I would like to invite Priya ma'am to give the vote of thanks.
Thank you so much, Advocate Karman, because today what we got to hear from you regarding the evolutionary mechanism of human rights and then coming down to India and then your own personal experience. I somehow am also elated to see how activist our judiciary is, and I feel proud to be a part of the same. And I am also hoping that the lacunas and the gaps which still remain unfilled are clearly filled up soon by the efficiency of the lawyers as well as the judges and everybody belonging to the legal community. And thank you so much, sir, for taking out time for your busy schedule. I totally understand your professional commitments as well, and in spite of that, you've come up and shown your presence here, sir. We are really grateful to you. Thank you for coming up, and at the same time, I thank the audience for joining in. even at the last minute where we have rescheduled the entire time, and still all of you showed up. Thank you so much, everybody. And see you all tomorrow again at 10:30 a.m. in the morning with Advocate Manik Mahe tomorrow. Thank you so much.
Thank you. Great. Thank you.
Yeah, thank you.